Mr. Speaker, thank you very much for this opportunity. Mr. Speaker, I want to begin by thanking all of those who spoke before me for their support of the bill. The bill obviously is a very modern expression of the law of trafficking in person. It has taken on board all the international recommendations and protocols and captures the United Nations position on the matter. Needless to say, Mr. Speaker, that trafficking in person is quickly or has quickly emerged as perhaps one of the most prevalent, gross, and pernicious violation of human rights internationally. As a result, it's an offense against the state and the person. Not only does it affect the victims, but society as a whole. More so as a transnational crime, the ripple effects of trafficking in person are felt throughout the world. Victims are principally subject to sexual exploitation, forced labor, and servitude. For these reasons, it is imperative that our regulatory framework is comprehensive enough to protect human rights of victims through criminalization and prosecution of this heinous act and the provisions of assistance to victims. Mr. Speaker, it's important also that we pay careful attention to the definition of trafficking in person. Many times I've read the international reports, you read reports in the press, and the definition is regularly enlarged beyond its technical tenets. And if we do that, then we would not be able to properly focus on what trafficking in person is as an offense. And that's why we have to reiterate the technical definition as adumbrated by the United Nations. And I wish to quote it for the record. It's defined as the recruitment, transport, transfer, harboring, or receipt of a person by such means as threat or use of force or other forms of coercion, abduction, fraud, or deception for the purpose of exploitation, unquote. And exploitation includes, at a minimum, the prostitution of others or other forms of sexual exploitation, forced marriage, forced labor or services, slavery or practices similar to slavery, servitude, or the removal of organs, as the Honorable Member just referred to. So I want to pause here to draw a distinction between trafficking in person, which can include prostitution, but prostitution itself, which remains an offense which can be differentiated from trafficking in person depending on the facts and circumstances. And those are the distinctions that we must be able to draw. And unfortunately, sometimes we discolor the distinctions and we lump offenses that are technically not trafficking in person offenses as trafficking in person. Reference was made, for example, to transplant of organs. You can have transplant of organs wrongfully done under the Transplant of Organs Act, but it doesn't necessarily mean that it is trafficking in person for transplant of organs. So all I'm saying is that we have conceptually in our minds, keep clear the international definition if we are to enforce the law properly and focus the limited resources that we have in the direction of addressing this serious crime. Mr. Speaker, the United Nations Convention Against Transnational Organized Crimes and the protocols thereto is the main international legal instrument in the fight against transnational organized crime, including human trafficking. The Convention's protocol to prevent, suppress, punish trafficking in person, especially women and children, the Palermo Protocol, came into force on December 25th, 2003, and represents a consolidated international consensus on the need to combat human trafficking. Not only does it contain the internationally accepted definition, and I just shared the definition with you, of human trafficking, but it sets out the responsibility of the state to prevent, suppress, and punish human trafficking. Guyana acceded to this convention in 2004, and in addition to the protocol, the obligation to criminalize trafficking in persons is expressly provided for in a number of international instruments, including the Convention of the Rights of the Child and the Convention on the Elimination of All Forms of Discrimination Against Women, both of which Guyana is a state party. Mr. Speaker, in fulfillment of our international obligation, the government enacted on the 7th of April 2005, the Combating of Trafficking in Person Act number 2 of 2005. At that time, Mr. Speaker, the law was the most modern expression of its kind. At that time, it satisfied all international requirements, etc. But this is nearly 2 decades ago, and much would have changed internationally and in relation to the way that this offense has grown, prevailed, and developed. So most naturally, we had to go back to the drawing board. And Mr. Speaker, in so doing, we engage in a consultative exercise. We consulted with the relevant international organizations for migration and key stakeholders, such as the judiciary, the DPP, constitutional bodies, such as the Rights of the Child Commission, the Indigenous Child's Commission, the U.S. Embassy, and NGOs. And they conducted a review of the 2005 legislation to identify its deficiencies. And out of that review, Mr. Speaker, out of that comprehensive review came this new bill. And the bill, Mr. Speaker, as we would have heard from the many presentations, is unique and different in many, many respects. So let me quickly address some of the conceptual changes that the bill introduces. So like the Sexual Offences Act, the bill disapplies a whole host of common law principles and even statutes to offenses involving trafficking in person. So prior to the enactment of the Sexual Offences Act, the record or the sexual record of a victim was a very important piece of evidence that could have been adduced. That was abolished under that law. Here, this act again says that that kind of information will not be admissible. Limitation. Every law, well, we have a limitation act that applies across the board to a series of transactions in civil law. And what it does, it prohibits the institution of civil proceedings for compensation if there is the expiry of a specified period in the act. This bill says that the Limitation Act does not apply. What that means is that victims of trafficking in person can institute proceedings in relation to the offense at any time. There is no limitation period. In terms of limitation for criminal offenses, this act says that the sections of the Summary Jurisdiction Offenses and Procedure Act, which limits the institution of criminal charges of a summary nature within a 6-month period, that those provisions do not apply to trafficking in person offenses. So though you may read in the bill that some of the offenses created here are summary in nature, for the purpose of limitation, they are indictable, that the limitation provisions of the summary law of the country do not apply for the purpose of time. Another important legal concept that this bill embraces is the principle of restitution. Now, in all transnational crimes, the international posture taken at almost every level of the hierarchical structure of the international agencies is the approach that now must be pursued in relation to transnational crime is restitution and the forfeiture, criminal and civil forfeiture of assets. The theory being that if you hit the criminal in the pocket, if you hit the criminals financially and you hit them economically, you are going to eventually hurt them. So in anti-money laundering offenses, in terrorism, in the trafficking of firearms, in the trafficking of narcotics, and in the trafficking of human trafficking, you find that that concept has been embraced fully in this bill. So even in, and what we have also done, normally, traditionally, you have civil forfeiture and criminal forfeiture of assets. And they had to have been done in different courts by different procedure and different circumstances. And you also had, well, restitution was not even available traditionally in criminal offenses. Restitution was frowned upon 40 years ago because the belief then was that criminals could pay off and get off criminal liability. The world has moved away from that, and now restitution is a penalty. Is a penalty. And the victim, because you get raped, for example, or you're raped, you are beaten, you are robbed, you are assaulted, you go to a magistrate's court, the man is fined, or the perpetrator is fined, or he's jailed, and you go home empty-handed. That system of justice for 100 years did not work, has not worked. So there has been an international paradigm shift now, and that is reflected in this bill. And that is why you see a large section of the bill deals with how restitution is to be administered, the factors that are going to be taken into account, etc. And also it provides elaborately for forfeiture of assets. So all properties acquired. My sister, the distinguished Honorable Member Valder Lawrence, spoke about money and the commercial gains that can be made and are being made from these activities. Well, this bill now allows the enforcement agencies to go against that accumulated wealth, proceeds of this criminal and illicit conduct. So you can destroy and dismantle all assets acquired from this activity or any other illicit activity. So those are very important concepts that the bill embraces. And these are the new concepts now that you will see being brought in the new legislation that will be coming to the House, especially in the area of transnational crime. The Honorable Member Lawrence also spoke to the absence of an oversight body, but I disagree with that position because Part 4 of the Act establishes a huge body, and I'll share that quickly. The President shall establish a national interagency task force to be known as the Ministerial Task Force to develop, implement, and monitor a national plan for the prevention and response to trafficking in person, with the responsibility of all matters related to trafficking, including sex trafficking, labor trafficking, which shall be jointly chaired by ministers responsible for home affairs and human services and social security. In addition, the President shall appoint the members of the Ministerial Task Force, which shall include A, the ministers and senior representatives in policy and technical implementation of the ministries responsible for. You spoke about a lack of technical policy implementation. Well, it provides for that. And in the areas that the ministries responsible for, legal affairs, foreign affairs, labor, home affairs, human services, Amerindian affairs, education, public health, natural resources, local government. Senior representative in policy and technical implementation of the Guyana Police Force, the Chamber of the Director of Public Prosecutions, Geology and Mines Commission, and any other appropriate high-level government officials, including officials with responsibility for law enforcement, immigration, natural resources, human Human Services and Social Security and other appropriate local government and non-governmental organizations or service provider. And then it continues a whole rest of the bill speaks to remainder of that part of the bill speaks to how they are to coordinate and administer and discharge their respective functions. Obviously, they have the power and the authority to co-opt additional expertise. So it does have a huge and varied and diverse governance structure, bringing together an impressive array of skills and skill sets and training to administer the act and to administer the government's policy and the state's approach to trafficking in person. The bill also speaks to the important principle of non-refoulement, non-refoulement. And this is a principle of international law which says that no person, well, every person or any person is guaranteed against being returned to a state or a society where that person is being victimized, terrorized, and being subject to inhuman and degrading treatment. This bill captures that. And the state, whether it's a refugee, whether it's a migrant, the state of Guyana will have to make provision in recognition of this principle of not sending the person back. The bill also makes provision in those circumstances how the status of the person will be regularized in Guyana, because obviously if they traffic and come here, they're essentially illegal. And so all of that, Mr. Speaker, is covered in the bill. Importantly, Mr. Speaker, the 2002 report of the U.S. State Department, I have it here, July 2002, and this report was carefully considered as well, and almost all the recommendations in this report were extracted and enacted or given effect to in the bill. So I would not go through all of them, but you would have read all the, you would have read the increased penalties, that's here, sentencing guidelines, that's in the report, that's in the bill, the reduce of delays in prosecutions and court proceedings, that's being addressed in the bill as well, and a whole host of other restitution, enforced restitution, that's in the bill. So many of the recommendations that were contained or that are contained in the U.S. report on trafficking in person, July 2022, have been incorporated in the bill. Mr. Speaker, a lot has been said about the statistics. Well, this report has the statistics from Guyana for up to 2022. So anyone who is interested in getting the updated statistics can get it from there. But I have we were speaking, a lot of references were made to human trafficking and smuggling in persons from Haiti, for example, and I have the figures here, reported to a parliamentary sectoral committee on foreign relations by then Minister Winston Felix. And he reported that 6,244 Haitian nationals entered Guyana between 2015 and 2018, but only 963 departed through a recognized port of entry and or exit, leaving unaccounted 5,281 Haitians. Then in a press statement dated August 16, 2019, he also stated that Guyana's immigration records show that 8,476 Haitians arrived in Guyana, but only 1,170 left between January and July 2019. leaving unaccounted for 7,576 Haitians. Add these two figures, 7,000 and 5,000, you get 7 and 5, 12, you get about over 13,000 persons unaccounted for who would have entered Guyana. The report, the US report, spoke about the government of Guyana needs to be vigilant in relation to Haitians, Cubans, and Venezuelans, etc. Honorable Member Ms. Valda Lawrence spoke about the inundation of foreigners that we will continue to have as our economic fortunes improve. And therefore, this bill and many, many new bills will have to come to prepare us to meet these new challenges. This bill resides in the minister the power to do regulations. So the bill is by itself it has some nearly 60 provisions, 59 provisions, and still yet it makes provisions for regulations to give effect to this bill. So it is going to be a comprehensive exercise when it is completed, and it will be a bill that will embrace many, many of the different areas that we will have to investigate, monitor, entry into Guyana, exit, then investigate, then accommodate, then prosecute and accommodate again, and then when persons are found guilty, then you have to accommodate them again, then you have to go after assets. During the trial, you have to deal with the issue of compensation. Then you have to deal with the victims in certain cases when they are left here. So it's a mammoth undertaking, and this bill will, I suppose, will have to be updated, and the infrastructure. A lot has been said about the implementation. So that is why the bill here doesn't come into force upon the assent by the president, but will come into force by an order to be appointed by the minister. Now, if you read the section or the clause, it doesn't bring the whole bill into operation. The minister can bring certain clauses into operation as she sees fit. The reason for that mechanism is to ensure that we have the machinery to enforce and implement the bill in an effective way. And that's why we have that strategic method of bringing the bill into being, into force. We have to ensure that many people spoke about the centers. We have to have the centers, and obviously we have to have them at different parts of the country. This thing is not confined to any given region. Obviously, you will have greater incidence of it being committed in one region as against the other. But based upon the empirical data available, it is something that's across the country. So we will have to have adequate capabilities across the country to do every one of the things that I have spoken about. Yes, training is very important. Our police force is under constant training to deal with these new and emerging challenges. You spoke about Facebook and the social media platform. We are working on cybersecurity bills and cybersecurity crime fighting strategies. Guyana is leading the Caribbean efforts at the level of the United Nations to negotiate a new treaty on cybercrime and cybersecurity. And out of that treaty will come model legislation for different parts of the world, including the Caribbean. Joanne Bond and Trishala Prasad, two young lawyers in the employ of the state, are leading Guyana and the CARICOM efforts in that regard at Geneva. So we have work that are going right across the landscape, and we can speak more about them, but time is going. So I lend my support to this bill, and I once again, I appreciate that it has been unanimously supported, but its implementation, as you have agreed and you have pointed out, is equally important. So this is only the foundation. The real thing now is to get this to work, and that will require every facet of our society. So we welcome you to continue to cooperate with us as we continue our battle against this international travesty. Thank you very much.